The courtroom is electric as the defendant faces Judge Simpson once again, and the tension is palpable from the moment he steps in. This isn't his first time in trouble. He's already on probation and was given multiple chances, yet he's back, accused of tampering with his electronic tether device and contacting the very woman he was strictly ordered to stay away from. Despite previous warnings, the alleged violation happened again, showing a pattern of disregard for the law. The charges are serious: a 2-year felony for interfering with an electronic device and a second domestic violence offense. Even though his lawyer claims the alleged victim doesn't want to pursue the case, the prosecution emphasizes that this isn't just about her, it's about repeated defiance of court orders and the rules that keep everyone safe. Judge Simpson's frustration is clear. He reminds the defendant that probation was meant to be a second chance, not an opportunity to ignore the law. When the defendant claims the victim chased him while he was playing a game, the judge shuts it down immediately. Excuses don't matter. He is under court supervision and must follow the rules no matter what. In a firm and decisive ruling, Judge Simpson sets a $100,000 cash bond, revokes his probation, and sentences him to 365 days in jail with credit for 162 days already served. He also orders him to complete an in-jail domestic violence program. This hearing sends a powerful message. The law demands compliance, repeated defiance comes with consequences, and no excuse can override the court's authority. The case is a sobering reminder that justice is serious, and repeat offenders will face the full weight of the system.
The PE is scheduled for tomorrow morning, I believe.
On the one case, I have a new case, however.
I was unaware there were new charges, Judge, but I don't know if this court's prepared to arraign my client.
I am.
Okay.
And I don't know. You're going to stand in for the purposes of the arraignment.
I'll be filing an appearance, Your Honor. I was unaware, but the charge, I would have filed one already. So.
It's a charge of interfering with electronic communication device, the 2-year felony, and then also domestic violence, second offense, the 1-year misdemeanor.
Yes, Your Honor. As it relates to both those charges, waive any further reading of the warrant. Stand mute to both those charges.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. I'll set a probable cause conference in that case for, I need a DV bond form, please. For November 14th, 2024 at 9 a.m. or as your invite indicates. As to bond in that case, you want to say?
Yes, Your Honor. Obviously, Mr. Carter's here on his own voluntarily this morning or this afternoon. And obviously the court knows his history of appearance in front of this court. Your Honor, he just got a new job. He was, unfortunately, he lost his other job due to this incident, but he just got a new job that he'll probably lose if he's in custody. Judge, it does appear that the complaining witness in both these cases is the same person who has actually reached out to me before, Your Honor's indicated her, I believe, unlikeliness of appearance in the case. I don't think she wants to proceed with the case, but that's my understanding anyway. People might have a different position, Judge, but she's reached out to me independently and indicated that she does not want to proceed with those charges. But be that as may, Your Honor, I don't believe my client's a flight risk, and he's on tether. What's that? He's still on a tether, Your Honor. He did post a significant bond in the last case. I understand these are new serious charges, Judge, but I'm asking the court to consider a nominal 10% bond, if not a personal bond in this case.
Your Honor, I have some advantage because I do have the police report for the newest case. Mr. Burgess does not, but I will indicate to the court a few things. First of all, this court arraigned defendant on not his newest felony that he was just arraigned on, but the one that's set for preliminary examination tomorrow on October 7th. At that time, the defendant was ordered not to have contact with the victim, Jennifer Matlock. The new date of offense for the newest case that we're here for today that the defendant is alleged to have committed is October the 20th. months later. And I will tell the court, after review of the police report, the person representing themselves to be the defendant, they had contact with the police officer and admitted to having contact with the victim. Denied the assaultive behavior, but did admit to having contact with her. Now, because the defendant, because the police officer wasn't speaking with the defendant face to face, I cannot say with absolute certainty that it was the defendant. However, the police officer did a very good job in their report of detailing how he came into contact with that person, that this person called him back or presented themselves to be the defendant, and said that he would turn himself in for the bond violation. I don't have a record that actually happened. So Your Honor, in any case, this is somebody that was on the score for probation, on bond for a felony, and now has picked up another new felony. So I am asking the court to follow probation's recommendation about the probation and sentence the defendant to serve balance at this time. And in bond in this case, we're asking for $100,000 for the new felony.
Court will order as a condition of the bond that there's to be no possession of any alcohol, illegal drugs, or any recreational marijuana. Better, I'm not entirely sure what is going on with you in that regard. I ordered you on the 7th not to have contact with this person. And then, lo and behold, we end up with this case occurring less than 2 weeks later. And tried to give you every benefit, and I understand there are only allegations, but try to give you the darn benefit of the doubt regarding everything because of at least the way that you conducted yourself in regards, particularly regarding being a flight risk. But you just can't seem to follow the rules.
Your Honor, I'm sorry. I don't mean to interrupt.
Go ahead.
I'm sorry, Judge. Judge, the incident on the 20th, based on conversations I've had with my client as well as the complainant in this case, the complainant approached my client, asked for a phone back he had purchased, but it was in her name, which he returned to her. That was the basis of the contact. That's our understanding of it, Judge. So I wouldn't. But.
Right. But the thing is,
I know.
He needs to be turning around and running in another direction. He shouldn't even be having a conversation, shouldn't be doing anything.
I agree.
Whatsoever. I don't think it's at all unclear as to anything that this court has said to you regarding what you need to do. And you need to just follow the rules. I gave you a break the last time that you came in. Even after that, let you go. You can say whatever you want.
She put up on me. I was in the room playing my game, and she came in the room. And
then you get up and leave.
Tried to leave. She kept chasing me. That's it. And then she wanted to talk about calling the police and all that. She's chasing me. She's chasing me. She's chasing me. I hopped in my car, and that's when I pulled off.
Well, maybe that's all going to come out, Mr. Carter. Maybe that's all going to come out. I let you out the last time. Should have, of all rights, locked you up on that date. Didn't do it. Gave you the benefit of the doubt because of the time that you came back after you were inadvertently released by the jail. And then what happens? You get that other case set for exam. Then what ends up happening? I get here and you got another case.
It's a control thing she's trying to do. That's it.
I don't care what it is. You have got all of these charges.
I understand.
And you're the one under the jurisdiction of the court. So however you got to figure it out, you need to figure it out.
Yes, sir. Yes, sir.
Defendant's bond on that case would be set in the amount of $100,000 cash surety. On his other matter, anything you want to say before I post sentence on that case?
I want to say, I tried my hardest. I tried my hardest to do right. I tried my hardest to stay away from women that want to see me in jail rather than see me elevate myself. So, I mean, I understand. I understand it. When I get out this situation this time, I'm gonna be by myself.
You know what you ought to do, Mr. Carter, and I don't mean to interrupt you. You have the right to allocute, but I'm just going to tell you something. You ought to quit blaming them. You
That-
just need to just stop blaming them and thinking that they're the ones that stop you from going anywhere. Because, young man, that is not the case.
Yes, sir.
You are smart enough. You can do whatever you want to do. You can stay away from whoever you want to stay away from. The problem is, quite frankly, you're just being stupid. You're just playing games. And this is what happens. You end up in jail on $100,000 cash bond, and you're about to go now.
I understand. I'll take full responsibility. I appreciate it.
Anything else you want to tell the court?
Oh, sir.
Judge, I don't know if it would have any impact on the court one way or the other, but I don't know if the court wants to wait to see the disposition of those cases, or if you're just going to follow the recommendation.
I'm not gonna wait. If there becomes a certain disposition regarding those cases, certainly I'll take that into consideration in modifying his sentence on the case, but I'm not gonna do that at this point in time. I keep giving him breaks, keep doing everything, and he keeps just coming back to this court, disappointing this court and ending up with more charges, just time and time and time again. And so in that respect, I'm done. I'm gonna revoke the defendant's probation. He is to complete the in-jail on farm program while he's incarcerated. I'm going to waive all remaining terms except the financial obligations on this case, discharge the defendant from probation without improvement. I will sentence the defendant to 365 days in jail, credit 162 days served. Defendant is to serve the balance.
Your Honor, the court ordered the Dawn Farm program. Probation also requested the DV program. So if you just requested DV, the court want the defendant to perform both or just one or the other?
I should have said in-jail DV program, is what I meant to say. Thank you.
The courtroom is charged with tension as the defendant takes his place before Judge Simpson. From the start, it's clear this is not a routine hearing. This is a man who has repeatedly ignored the court, defied its orders, and tested the patience of the justice system. He is back in front of the judge, accused of tampering with his electronic tether device and contacting the very woman he was strictly ordered to stay away from. The weight of his repeated offenses hangs in the air, and everyone in the room senses that this hearing will not be like the others. The charges he now faces are serious and reflect the gravity of his actions. He is accused of interfering with an electronic communication device, a 2-year felony, and a second domestic violence offense, a 1-year misdemeanor. Even though his attorney claims the alleged victim does not want to pursue these charges, the court makes it clear that this case is about more than her wishes. It's about accountability, responsibility, and the repeated defiance of court orders that were meant to protect people and uphold the law. Repeated violations cannot be ignored, and the court is ready to ensure that justice is served. As the hearing progresses, the prosecution lays out the details of the defendant's actions. He was explicitly told not to contact the victim on October 7th. Despite this, on October 20th, he allegedly reached out to her again. The prosecution emphasizes that his previous probation was a second chance, a period meant for him to demonstrate that he could follow the law and respect court orders. Instead, he has returned to the same patterns of behavior, and now he faces far more serious consequences as a result. Judge Simpson's demeanor is calm but firm, his frustration barely concealed. He reminds the defendant that the court's patience is not limitless. Probation, leniency, and the chances he has been given are privileges, not rights. Every excuse the defendant offers, every story about circumstances beyond his control, is met with careful scrutiny. When the defendant claims that the alleged victim pulled up on him while he was playing a game and that he tried to leave but she kept chasing him, the judge immediately rejects the explanation. The point is simple. He is under the court's jurisdiction, and it is his responsibility to follow the law no matter the situation. Excuses do not absolve him of the consequences of his actions. Throughout the hearing, the tension in the courtroom is almost palpable. The defendant struggles to maintain composure as the judge delivers a clear and unwavering message. Compliance with court orders is not optional, and repeated violations will not be overlooked. This is more than a lecture. It is a warning, a clear statement from the court that defiance has consequences. When the ruling is delivered, it is firm, decisive, and unambiguous. The judge sets a $100,000 cash surety bond, revokes the defendant's probation, and sentences him to 365 days in jail, giving credit for 162 days already served. In addition, the judge orders that he complete a domestic violence program while in custody. This combination of punishment and mandated rehabilitation underscores the court's approach. Accountability comes first, but opportunities for learning and correction remain part of the process. The defendant's repeated disregard for court orders highlights a larger lesson about the justice system. Probation and leniency are opportunities to correct behavior, not invitations to ignore the law. When someone continually violates court orders, it puts themselves and others at risk, and the court must respond in a way that protects the integrity of the system. Judge Simpson's approach demonstrates this balance clearly. There is no bending the rules for repeat offenders, but there is still a path forward if the individual is willing to take responsibility for their actions. The hearing also brings into focus the role of the judicial system in enforcing accountability while promoting rehabilitation. The domestic violence program ordered for the defendant is not merely a formality. It is designed to educate, prevent future offenses, and help individuals understand the impact of their actions. At the same time, revoking probation and setting a high bond sends a strong message. Repeated offenses will lead to tangible, serious consequences. As the courtroom proceedings unfold, it becomes evident that the judge is focused not just on punishing the defendant, but on ensuring that the law is respected and that repeat offenders understand the stakes. Each statement from the judge reinforces the principle that no one is above the law. The defendant's excuses are systematically dismantled, emphasizing that personal narratives cannot override legal obligations. The case also underscores the importance of responsibility. Every action taken by the defendant, every decision to defy court orders, carries consequences. The justice system exists to maintain order and protect individuals from harm, and when someone repeatedly disregards that system, the consequences must be severe and clear. Judge Simpson's ruling exemplifies this principle. For viewer, this hearing is a stark reminder that the law is serious. Second chances are real, but they are not infinite. Repeated violations, disregard for court orders, and excuses that fail to acknowledge responsibility will inevitably lead to strict consequences. Judge Simpson's handling of the case demonstrates the balance between firm accountability and structured rehabilitation, ensuring that justice is served while still providing a path for correction and growth. In this courtroom, the message is unmistakable. Repeated defiance, repeated excuses, and repeated violations will not be tolerated. Compliance with court orders is non-negotiable, and the justice system is prepared to enforce that with authority. The defendant's sentence, the bond, and the mandatory program all serve to reinforce the seriousness of the situation. This case stands as an example of the consequences of ignoring the law and the importance of respecting the court. Judge Simpson's no-nonsense approach leaves little room for misinterpretation. The system is serious, repeat offenders will face justice, and excuses cannot replace accountability. For anyone watching, it is a powerful reminder that actions have consequences, and the law demands respect. Every moment of this hearing highlights the stakes, the tension, and the responsibility of those who come before the court. It is a lesson in accountability, the limits of leniency, and the enduring importance of following court orders. The courtroom becomes more than a setting for punishment, it becomes a place where responsibility, consequences, and the possibility of reform all intersect. The defendant leaves with a clear understanding of the consequences of his choices. The law is not optional. Compliance is not negotiable. And repeated disregard will always lead to firm consequences. Judge Simpson's ruling is a powerful illustration of the balance between justice and rehabilitation, a reminder that the legal system is serious, and a warning that repeated offenses carry a price that cannot be avoided. This long, tense, and instructive hearing ultimately reinforces one message above all: the law matters, accountability matters, and the choices we make have real, unavoidable consequences. The courtroom becomes a place where responsibility is enforced, excuses are rejected, and justice is served without compromise.